Carl Pearson, and as you can see, I'm running my own camera. And this is a video on defending a frivolous trademark infringement action. It's an important video for those people who have been sued or might be sued for alleged trademark infringement. My name, as I've said, is Carl Pearson. I've been an attorney for more than 40 years, basically in commercial cases, mainly in federal court, but often state court. And here is a copy of my website address over here. So, and I'll show it at the end of the show, just so you can see the website that has further information. The owner of a trademark is entitled to damages, treble damages usually, for infringement of the trademark. But this isn't what drives the recent plethora of trademark cases that are swamping the courts as I see it. Instead, it's the statutory damages of $1 million per product category, per trademark, that seems to be driving what is essentially a bounty market, where lawyers are looking desperately to find people to sue by hiring paralegals and investigators and making phone calls, making purchases of products, and then using that as a pretext for bringing a lawsuit. And this is driving people that are subject to these lawsuits to believe that there is nothing but a frivolous nature to these lawsuits. So I'm going to explain why people believe these lawsuits are frivolous. And I'm not taking that position myself. I'm just going to explain this to you. That the lawyer that brings the suit hires a paralegal or investigator to look for people to sue, and as soon as they do, and they get evidence by a purchaser or some other act, such as calling the store and having a store clerk say, yes, we can provide that to you, then they use that as a basis for suing. And there are no damages usually. In many of these cases, not a penny of damages can be proven, and the lawyer seeks $1 million or more of statutory damages, which is the reason that the case was brought in the first place. It isn't actual damages, it's this bounty of $1 million that you might have to pay. The law firm, before filing the action, wrote you a letter demanding $5,000, $10,000, $15,000, $20,000. Otherwise, they will bring suit to you, which you believe is extortionate, and therefore the whole case is frivolous. The owner of the trademark is apparently not getting any money out of the case at all. The money for which settlement is made seems to be going to the attorney, and what's the client getting? And that, you think, is an indication that the lawsuit is frivolous, if not illegal and immoral and reprehensible. The law firm is not getting paid other than out of this contingency, meaning that you pay the lawyer, no one else does. And the law firm has been criticized on internet for this kind of tactic. And finally, they're suing you as an individual in addition to the corporation, and you didn't do it. It's the corporation's liability. And why are they suing you? Now, these are the grounds that you think make the case frivolous. The courts, however, are not taking that position. And I have had many of these cases, and I do not find that there is as much court decision or thinking in your favor as you would like. That most of these things have been revealed to the court, and the court generally doesn't get shocked and say, oh my God, we got to put a stop to this, so that the litigation continues, your expenses continue, and we really have to take a look at what you should be doing in your defense instead of talking about how frivolous the case is. You try to settle the case. At all times you try to settle the case, but the lawyer will demand more and more and more and want more discovery and never really be able to be satisfied that you didn't really have that much in sales and that you didn't have any profits and therefore they really don't seem to want to settle except on at this excessive amount unrelated to what you did to damage the people. And that's because of the statutory damages of $1 million. You have to defend on a timely basis and make a motion for a lack of personal jurisdiction or insufficiency of service of process, but factor into that whether or not you might just be sued anyway and have to go through this again, and is it not just an additional avoidable expense. You want to provide the information demanded by the other side as quickly as possible because you want to reduce attorney's fees on both sides. You want to push for the unconstitutionality of the statute and attorney's fees as being excessive and punitive in nature, with the recent decision of the Supreme Court involved saying that you shouldn't have punitive damages exceeding a single digit of actual damages. And push for a determination of the impropriety of the lawyer's actions. If you see that settlement isn't going anywhere, you should start pushing at some point. Finally, you might just have to go to trial, and there the strategy is keep your expenses down as much as you can, and then argue to the jury that the $1 million is excessive. It should only be 3 times the actual damages. The damages were only $1. So give the plaintiff $3 and send them home. That's the argument that you should make. Furthermore, deal with a lawsuit very seriously, even though you think it is frivolous. The courts generally have not gone as far as you would like to say, and therefore you've got to treat this very seriously, because they are serious cases and you could have a huge dollar judgment against you personally and the corporation. Copyright cases have a similar problem. For an 80-cent download that you avoid, you might have to pay $150,000 in statutory damages, which is 187,500 times the amount that you may have downloaded illegally. So if you want to discuss your case, please give me a call. I can handle cases anywhere throughout the country, and when they're not in New York State, I do it through use of local counsel. Let me show you once again my website address and my phone number, 212-307-4444. There's no charge for consultation. Thank you.